Some critics observing her arrest being arraigned in court, some of even the orders given, have seen it as special treatment being given to a suspect, and that the office she holds has been amplified. And some would even dare ask, if she were to be found guilty, would she go to a special prison, for instance? Did you see those concerns about a double standard in how she was treated and how other suspects would be treated?
No, I didn't see any double standards. I think we've been blamed for arresting people on, not me, but the DCI, for arresting people on a Friday. We had been given time limits. We have, of course, the 24-hour requirement. We tried to observe that. And we charged the DCJ.
Did not object to bail. We've many times seen objection to bail. We've seen cases go late into the night, even 8:30. This one was...
That was not within our purview. It was the judiciary. They had to make that decision. We were asked to come the next day, which we obliged. We also considered the fact that the other side of the coin is the argument is, of course, the issues of revisiting, the issues of being unfair. That would also have come if we took the other way. The fact that we made that decision to prosecute in itself, I think, was earth-shaking. Mm-hmm. And that was enough. Yeah. The DCJ is a very senior person. We didn't see the point of opposing bail. We don't see where she would be running to, if at all. And those are some of the considerations. In terms of interference, we didn't feel that she would interfere because we had enough of the evidence. They were all secured. So there were many factors that we took into consideration, just like we take with all other persons. Mm-hmm. And if you look at some of the cases that we opposed, there were reasons, and we gave the reasons as to why. Of course, when you're also investigating, you will see how the person also reacts to investigations. I think the DCJ, to her credit, was very calm. Even though at some point I think it came to our attention that investigations were ongoing, she did not try to meddle. Mm-hmm. In some of the other cases, we have seen individuals meddling, and that's why when we go to court, then we oppose. Yeah.
Let me take you back to that point on the JSC, and you say you're rightfully seized of this matter. I spoke and interviewed a JSC commissioner and asked if they would consider still parallel taking over this matter as a commission. In your view, would that be in order?
In my view, I mean, they can still go. That is a disciplinary case. Mm-hmm. I mean, the ambit, in my opinion, of JSC is disciplinary in nature. It's just like the PSC or the Public Service Commission or the Parliamentary Service Commission. They can go on with the parallel process. We have no objection to that. But this matter of the criminal, in my opinion, should proceed. Yeah. But it's before the court of law. And as I've said, and I think my deputy, Madam SPP, had alluded in court that we will respect whatever decision that comes. Yeah.
Other judges, of course, who've been charged in the past, GBM, Chitembwe, for the matters, they stayed out, did not preside over cases. And for judges, there is no law as we speak, at least that I don't know of, requiring them to stay out of matters. It's pretty much left to them. And there was also that debate going on. So does she continue sitting the JSC? Does she continue sitting in the Supreme Court over matters? Should we have a law that strictly outlines that?
Is she sitting on any matters that you're aware of?
If they come up, she's still in the JSC, she's still a judge.
The discretion is with the institution. Mm-hmm. But I think the Constitution is very clear on integrity. We also have the anti-corruption in our SECA that is also very clear about state offices and public offices. Mm-hmm. Ideally, I think a person should step aside.
We don't need law.
No, the law is there.
It's on economic crimes, not specifically judges. Yeah.
Well, it covers, in my opinion, all state officers, and I don't know if I'm wrong, but it also does cover the judges. But it's also left to the institution. All that, for example, EACC can do on issues of integrity is ask them and remind them of the act and the requirement. I think if you look at the executive, that is the precedence now, that the PS, for example, has to step aside. So does the CS. And we expect the same. Once this matter is adjudicated, whether it will be taken by the JSC or whether the courts will agree that we should proceed and charge, then we would expect that she will, step aside, and anybody in that situation.
Part of the legal fraternity has also been debating around when a suspect has not taken plea and the suspect moves to a different court seeking to stop the process. Can that, say, High Court determine a matter that's not on record properly? It's something that has been pronounced out there, but it's not seized of the court.
Yeah, it has jurisdiction, and it can. I don't see any problem with that. I know what we have been trying to argue is that anticipatory bail should not be entertained. In jurisdictions like India, I think there are clear judgments now, and that this is something that should not be entertained. And hopefully we shall also move to the same and ensure that it doesn't happen, because most of the time it is just to derail the process, conservatory orders and on all this, but it's within the ambit and the powers of the High Court.
Anticipatory bail, you mentioned that because there are those who would argue it also helps protect the person, and in a sense they're telling the court, I'm here, at the point I'll be charged or summoned, I will appear, but I'm not running away. So that you see it differently. You see it as a hindrance, an interference of sorts with pursuit for justice.
Yeah, because, there are certain processes, for example, the DCI has to go through. And when you have that, it really complicates that. But, it's still the law, and we respect it. But I think we have been opposing it, and we've become more proactive as the ODPP, and we will be more proactive to ensure that such bail or anticipatory bail does not or is not used to hinder investigations.
Help me understand how it does that. Is it that people will run away, not show up?
Well, there is that, but there is also issues of, you have to be processed with the DCI. The time, sometimes you need the full 24 hours. Sometimes you need more than that, depending on the number of suspects that you have, like the NYS case. So time, 24 hours is not enough. When you have an anticipatory bail, it's even less. So there are those issues.
You mentioned NYS, and let's talk about that a little bit. They're now called or described as NYS 2. Yeah. At least 50 people have been charged. And what was reported was that 9 billion shillings was lost from the National Youth Service. But the charges against these individuals is touching on 400 million. Yeah. So that the question that follows is, what about the 8.5?
I think I've talked about this over and over. We had phases, or we have phases. And the first phase, we looked into about 1 billion. These are pending bills. They were worth 8 billion, not 9. Okay. And when we looked at the 1 billion, that dealt with the transport department within NYS, we found that approximately, roughly, if you round it off, about 500 million out of the 1 billion were fraudulent.
Okay.
And these are the people that we decided to charge, because if we were to wait and dispense with the whole of 8 billion, it would have taken very long. And more complex in terms of what we were looking at. We needed auditors to help us. We needed forensic auditors. We needed to look at, in some instances, even computers, and you need also forensic analysts in that. And we felt that time was of essence, and we could move with that, with the fast one, because they were simple, they were straightforward, and they were not very complex.
Yeah.
We are now looking into the rest. We are very soon going to come up with, before the end of the year, another set on NYS. And I think we're looking into an additional 2 billion. And we will do it in phases and complete it up to the end of the 8 billion.
Okay.
Remember that even with this one, we had banks involved. And from what we did, you saw last week that banks were fined. And that was part and parcel of the investigations that we started, and that's what I had promised Kenyans. It's a long process. On this, we had to look at the money laundering aspect. We were becoming a bit more sophisticated also on how we are investigating these crimes. So we looked at how the money was laundered. We looked into how we were going to freeze the assets and accounts. Seize the assets and accounts, forfeit them, and see the process of forfeiture to the government once we convict them. But it has been a very involving investigation, just on that phase alone. Yeah. And you can imagine what it will take us once we move to more in terms of the amounts. Yeah. So we are being holistic in our approach, and we didn't want to be one of those simple investigations that then
fall apart.
Fall apart, or two, even if they're convicted, then they still have the proceeds to enjoy.
So freezing of assets, recovering, of course, of the same.
And tracing the money where it is, that's a very complex. Considering that most of them withdrew cash, tracing cash and how they used it is not easy. And that's why we're enforcing and we've penalized the banks so that we can have systems that are traceable, that would be easy for us to investigate, that would discourage graft.
And still on that, former PS Omolo, former DG NYS in Dubai, their cases are set to begin January 2019. And we understand the prosecution, defense, in pre-trial conference agreed to this, and some would wonder.
I think
why.
That's a misunderstanding.
Okay.
One, the court directed us to consolidate these cases, and we have 3 files now. I think we had a total of 10, but they've asked us to bring them together. So we have a cluster of 3. And in all the 3, these individuals appear. And the first one will start in October.
Okay.
First one being handled by Honorable Ogoti. The second one will be in January. This is the one you're alluding to. Okay. And the third one will start in February. One thing that Kenyans need to understand is the courts also have diaries. And they have so many matters. And I think, to give them credit, they had to move matters to accommodate these cases, just as directed by the CJ. So, for example, the one that starts in October, we anticipate that it will take up to December for it to be dispensed with, hopefully. And that's the time frame that we have put. And the rest. And I think this has really been, it's been expedited. Considering what I've told you in terms of, how complex the investigations themselves are,
Right.
and the many different components. At the end of it, it is the judiciary that gives the dates. Yeah.
One of the biggest concerns in as far as seeking justice in Kenya has been how slow, the judicial justice system is. You have a case sometimes take 10 years.
I think it's all over the world, and that's why we have the
Is it?
yeah, that's why we have the saying. Yeah, you know how it what the
justice delayed.
No. It's slow.
Slow.
But
I know
it grinds and it grinds finally.
Justice delayed is justice denied.
Well, there is that.
Yes.
But the wheels of justice are, they move, they're slow, but they grind.
Should it be that way?
No, of course, we are trying. We have to look at our circumstances and our environment. I think we're trying our best, and the judiciary is trying. They've built more courts. They're recruiting more people. There was a standoff, but I think that has been cleared. You had what the president said, that there'll be more funding to the judiciary. For a long time, I think the ODPP was forgotten, and people only looked at equipping and funding the judiciary. But I think a lot of people forgot that this is a chain, and it's a justice, it's a criminal justice chain. It's a link chain where you can't cut it.
Yeah.
And if you are to work on it, you have to work on it holistically. So the police, so that they can investigate on time and expeditiously, but also have the capacity. I think that has been done very well for the police, the EACC. Now, I think the president has also said that we are going to be funded, despite the austerity measures. We are one of the few, together with the judiciary. Yeah.
But is capacity in terms of the staffing at ODPP an issue with the numerous matters you have? Here you're talking about there's NYS2, you have the Kenya Power, you have numerous cases, of course, that you're canvassing. Is also that an issue that sometimes you'll ask for extra time because you're stretched thin?
We've never asked for extra time.
Okay.
I think we've improved in terms of the speed, and this is part of management. I think myself and my team, my deputy and the other deputies, we've sat down and come up with a plan of how we can make sure that we also expedite the process.
Okay.
Yeah, we have very seasoned lawyers. The problem with the media has been they concentrate on the defense, and they talk about very able defense lawyers, forgetting that we also have very able prosecutors who have prosecuted matters in here and got convictions, who also give a very hard time to the defense, and most of the time.
So you have senior counsel type of.
Yeah, we have. We still need. I mean, we need more.
Yeah.
And as I said when we started NYS, I will bring on board special prosecutors from the private sector to help us, and we are working on that.
We saw NYS 1, most, if not all, I think there was one case that was still ongoing, but all the others were acquitted. And no one held to account. Of course, questions are always, will we see the same replicate with this? We'll wait to see. But as ODPP, of course, you're not in office at the time, but has there been a time to reflect, look inwards, how that matter was handled? Could there be any lessons learned, something done differently?
If you are to look at Kenya, when it comes to matters of graft, I think, and you can look at your statistics, we've done pretty well.
In terms of
even getting convictions. If you look at, well, the numbers, the percentages, I think, are about 80% if I'm not wrong. I can't remember it offhand, but it's, and if you're to compare in Africa and even globally, we've done very well.
When you say 80%, let me just hold you to that. Many would wonder which ones, because many times what Kenyans keep talking about is where the convictions, we're not seeing the small...
Not only Kenyans, but also the media only look at the big cases. But there have been many, cases, smaller, what you would call smaller cases.
And there we see expeditious justice served.
Because they're not complex.
Okay.
Yeah, so if it's a traffic case, it's not complex. Even the consent is given much faster. It's straightforward, and it can be dealt with, very quickly. But when you have like NYS, you have 50 individuals. You're talking about millions of shillings. In this case, part of that money was used then to now, they laundered it in such a way that they were then able to engage in what you'd call, legitimate business, but from proceeds. So we are looking into that also. We are going to try and bring that out also in court. It's complex.
Okay.
And lessons learned. That's why we're looking to how they laundered the money. We are looking at, freezing their accounts, seizing the assets, so that they don't use that to complicate the cases for us. Before they would get very good lawyers, a battery of lawyers, and what else also went behind the scenes.
What did?
Oh well, we are all Kenyans, in terms of corruption and all that. So whether it's corrupting the judiciary or corrupting the DPP or corrupting the police, that did happen. And I've said this before. We can't put our heads in the sand.
But do we know this? If we know this happened, have we sought them out? Because then those are bad.
We're sorting them out. And that's why I'm surprised that we are being vindicated, for example, by taking on some individuals. We are trying to sort that out.
So when you say you're looking at that, so there are investigations across the chain, I mean, if you can speak to, because the judiciary, there have been a lot of allegations around corruption there, prosecutors, investigators, that sometimes is part of the problem, part of why we never see justice at the end of the day, because the process is compromised by the suspects. Yeah? So you're looking at that?
Yeah, we're looking into that. Yeah, and you will also see cases being brought for us to prosecute. And this is why it is very important for people to understand the mandate of the DPP, and I think the DCJ's case is going to be a milestone for us, so that parameters are defined. Can we prosecute a sitting judge or not?